Any mention?
May please, Your Lordship. Lordship, I beg to mention item number 25, my lord.
Yes.
My lord, it's a joint request, my lord. I believe the matter can come after 2 weeks.
No objection. 25. Impairment done. You are a state respondent.
Lordship.
Yes. Impairment register. Ranjan on it. GA appearing for the state respondent. This is met after 2 weeks. Yes. Yes.
Lordship, item number 13 and 14. Lordship has been fixed in the main hearing list. However, they have challenged the maintainability of the revision petitions. So, Your Lordship, I pray that it may come under the admission hearing stage.
Doesn't matter.
This
if it
has
remains the
become
hearing also. The question of maintainability will remain open.
yes, my lord. May I just submit, my lord? This I have the order. This has become infructuous. The case, the main case, the title suit has been disposed of, my lord. I have the order, but we will supply in the course of the day, my lord. We have little issue.
I have no. Let me get instructions, Your Honor. Because
Maybe after a week, then, my lord. By then, I'll also get my.
Then you come back with instruction after a week.
Yes.
Okay. On prayer made by Mr.
I'll,
Wait. Let's on just 13:40. On prayer made by Mr. Thava. Oh, this the main case, the main suit. It is
Yes, the main suit. The main
has been
suit.
disposed of.
Dispose of, my lord. There's an order, my lord. They have sent us in a scan copy.
You have a copy of the order.
My lord, they have sent us, but it's the way the manner
not,
it is
not
scan.
taking it this thing. We'll just
Yes.
adjourn it for 1 week. Just
My lord,
come
my
back
lord.
with that. And meanwhile, you also take instruction.
yes.
Just on prayer made by Mr. D. Thava, and counsel for the petitioner. This is met after 1 week. Yes.
My lord, obliged.
Highly obliged.
Please, Your Lordship. Your Lordship, item number 1 and 2, Your Lordship. We're still awaiting instructions in this matter, Your Lordship.
These are those
CMG matter. After 2 weeks, Your Lordship.
Mr. Nongbi, Philemon Nongbi is the
Yes,
special
Your
counsel. This item number?
1 and 2, Your Lordship.
So what do you want now?
We're still waiting for instructions, so I'm just praying if this matter can be taken up after 2 weeks, Your Lordship.
No objection, Lordship.
On prayer, I don't know. We have a Mr. Philemon Nongbi, London Council appearing for the. He's appearing for the state
State
respondent.
respondent.
Yes, we are appearing for the state respondents. Come on, not objected to by London Council for the petitioner. This is matter after 2 weeks.
Yes, Your Lordship. 2 weeks.
Yes. 1 and 2.
Lordship, may.
Yes.
Lordship, I beg to mention item number 12. Lordship, the constructive counsel for respondent number 2, Miss N.M. Kharshimlang, is not well today.
Yes, sir. This actually, I think our submissions are complete. But anyway, if they one time
This private respondent.
unwell also. 2 weeks, Milord?
1 week, sir.
Huh?
One.
Next week I will not be available.
After
After 1 week, it will not be possible. Here also, roster also will do that. After 2 weeks, it will go up.
2 weeks. 2 weeks. 2 weeks.
Yes, on prayer made, and we have the response number. Your response number?
2.
This is matter after 2 weeks. Yes. You give your name. Just
Yes.
you are you advocate on record?
Yes, Lordship.
By so and so. Just
Obliged.
Item number
6
6 and 7 on joint request latest matter may be listed after 2 weeks, Your Lordship.
what are this matter about?
This is pension matter and pension and disciplinary actions.
There's a disciplinary proceedings.
Disciplinary proceeding has been drawn up, yes, against the petitioner.
6 and 7. Both are
Yes, connected.
joint prayer made with the parties. Disturbed for 2 weeks. Yes.
Highly obliged, Your Lordship.
Item number 3.
Lordship, this is that Lordship will recall this is a matter where they relied on a.
Oh, that.
We had given them a copy, and last date they thought they didn't get the copy, and they wanted some time. Do you have any objection to that? I don't know. Nobody's here.
So what is to be done?
So after 1 week, maybe they're still.
After 1 week will not be possible. It will go after 2 weeks.
Absolutely.
Then appears for the petition.
Absolutely.
Mr. Khan, along with, so is present on behalf of the state respondents. There is no appearance on behalf of the respondent number, private respondent number.
Private also is not there. 6.
Just check who is private respondent.
Private
number.
respondent.
Let me say, this matter after.
Oblige.
Item number 4.
Yes, Lordship. Lordship, this matter hearing has been concluded, Lordship, and we've already filed our written argument also, Lordship. Now it is for the respondent 5 to 7, Lordship, to file.
We do, we have filed everything.
Where is Mr. Demnath?
In the last occasion, he sought 1 week time, Lordship, to file his written argument.
We have served the copy, Lordship.
Where is he? He also has to
And
give
Lordship,
his points, isn't it?
he's been asking time for several times now.
Just say, so and so present, Mr. For the petitioner and so and so. Yes. What is this?
Written argument. Okay.
You submitted gist of submission, isn't it?
Lordship.
Same.
It was submitted on which date?
Yes.
On 6 Lordship. 6 on 6 June 2025, Lordship.
6th June.
Yes, Lordship.
That is brief bullet points, isn't it?
Yes, Lordship. Brief bullet points.
We filed it here.
It was heard in the month of June, isn't it?
Yes, Lordship.
And then it's a service matter.
Also filed it here.
Is this a service matter, Mr. Kharvi?
Yes, yes, Lordship. Teacher matter.
And then you are supporting the state or you are supporting the petitioner or the private respondent?
No, Lordship, we have filed this written argument. There are some points which we have mentioned in this
Okay.
written argument, Lordship.
And it goes in whose favor?
None in favor. Lordship, in this matter, the first matter, we have filed the first matter. Mr. Kipi is appearing. He's a
Can you just
main counsel here.
Can you refresh the thing? Since it was heard in June, this court also.
Then in that case, Lordship may fix this matter on the either tomorrow or after a week, Lordship. I'll inform my senior. Because senior has argued this matter, Lordship.
Lordship, in this matter, just I'm giving this bullet point today,
Yes.
and I'll be Related upon the earlier list of submission given, I mentioned it here, and little bit points I have given on the bullet point.
This is that case, Lordship, where the writ petitioner is the teacher who has been removed on the ground of he did not fulfill the requirement. But he was, another private teacher was appointed in his place who also did not fulfill the criteria, Lordship. That's the case.
So you have challenged that, isn't it?
Yes, Lordship.
And why there are two writ petitions?
It's a connected writ petition.
Why
Similar
connected means
issue,
why? Why
Lordship.
there are two writ petitions? What is the reason?
Not the correct petition, Your Lordship, they are here.
In the second writ petition, we have challenged the appointment of the private respondent.
And the first writ petition?
We have challenged the dismissal order, Lordship.
Your Lordship, first writ petition, he has asked for the salary, not for dismissal. So when he asks for salary, then we file our reply. And then in our reply, we have given this.
We'll just
It was for the
we'll have it in the next week then. If possible.
Lordship.
Will it possible to?
Lordship can fix this matter next week, Lordship. We'll brief.
Next week there is only 2 working days. There is a problem.
In that case, after
We have fixed one matter. Yesterday also we fixed another matter. Yesterday also we fixed another matter for next week.
So, Your Lordship, I am giving this bullet point.
It will go after a week. You see, please.
subject to Lordship convenience, also any day.
We'll try after holiday is over. Just okay. Just the
Your Lordship, with the permission of the court, Your Lordship, I may be given the copy. This one, this serial number in this page. There some similar comes. Let me. The real page is one. The page number, all the pages has come one.
1111.
Yes, yes.
Will it matter?
So just I will changing this one. This page. Can I make the handwriting?
Please. There's no problem. Yours is only two-page argument, isn't it?
PG.
Doesn't matter. Yes, you have gone through these bullet points. You are him? Or?
Lordship, his bullet point.
Yes.
I've just received, Lordship, just now.
You just see, go through and just see if you have anything to say on that also.
Yes.
You just say, Mr.
Will
Devnath.
apprise on the next date, Lordship.
In both the cases, this one argument will cover both the cases.
Yes, Lordship.
Okay, Mr. Devnath, Honorary Counsel. Appearing of the response number 527 has submitted written bullet points of his argument. Stop. As prayed for by the parties, this is matter after a week. This is already gone, this spoiled things. How we will go through this? Just see. How we will read this? This part is gone. That is okay, but then if we cannot read it, then we'll have to take. This is in opposition, response number 1, 2, 3, and 4. Mr. Kharmi,
Yes,
you
Lordship.
response number 1, 2, 3, and 4, isn't it?
Yes, Lordship. Respond one,
Now,
two, three.
you have a copy, extra copy of your affidavit in opposition.
I'll make extra copy, Lordship.
Please supply us. See, the copy, the office, copy, the record is totally torn. We cannot even go through also.
We'll furnish it, Lordship.
Please, if possible. Okay, just escort with the parties. This is matter after a week. You please supply us a copy on the next day.
Yes, Lordship.
It will not be possible. This is gone already.
Before next day.
For any of the parties, whoever has extra copy.
You will give that, Lordship.
Affidavit in opposition of response number 1 to 4.
1 to 4, yes.
Just say as provided by the parties. This is matter after 1. Yes.
Outline.
Obliged, Lordship.
Item number 8.
Please, Your Lordship.
Yes.
My Lord, may kindly recall that recently we were impleaded, Lokayukta was impleaded as a party copies of writ petition was received, sent to the Lokayukta. Instructions have come, my lord, with pairwise comments requiring us to file a small affidavit, my lord.
Yes, Mr. General, Honorable Counsel, applying for the respond newly imputed respond number 3 submits that an affidavit in opposition on behalf of the said respondent will be filed in the matter. Stop. He prays for front of some time. Prayer allowed. List after
2 weeks.
2 weeks.
Obliged.
50.
Next.
This is another matter which was heard on many occasions.
My lord. In fact, the last hearing was quite some time back. So if your lordship allows, I'll just take a few minutes just to refresh.
Please refresh, please. Is there any written notes of argument by you, Mr. General?
My lord, not yet, my lord. I was waiting for the hearing to be complete.
You'll file one written.
I will, my lord. At the conclusion of the hearing, my lord.
Yes.
My lord, I'll just take a few minutes. This is regarding the seniority issue, my lord, regarding MCS officers. First aspect, my lord, was the 2022 judgment passed by Justice Banerjee, sitting in the single bench, where he decided that the private respondents would be senior to me as far as the junior level post is concerned. And he was very clear, he is not speaking of what happens after promotions. That aspect is very clear. Lordship is also very clear in Lordship's mind that Justice Banerjee's 2022 judgment will only decide the situation as far as junior level post is concerned. Now, my lord, promotions have come. Now we are in the senior level post, my lord. So for the senior level post, Justice Banerjee's judgment will not apply. The rules will apply, my lord. Number one. Number two, my lord, as far as the rules are concerned, Rule 16(4) is there. The gradation list which we have challenged, the gradation list of 2022, has been prepared under Rule 16(4). Now, 16(4), my lord, if lordship recalls, says that seniority is based on my position in the merit list, in the original merit list. So, in the original merit list, I was senior to private respondents. So, if the impugned gradation list gradation list, my lord, claims to be prepared, to have been prepared under 16(4), it has to reflect my seniority in the original merit list, my lord. But it is not doing so.
16(4) applies to the promotional post also?
Yes, my lord, it does. In fact, I'll just come to that also. So, undeniable fact, my lord, is that the impugned gradation list of 2022, which I'm challenging, claims to have been prepared under 16(4). So if it is prepared under 16(4), my seniority in the merit list, in the original merit list, has to be maintained. Impugned gradation list does not maintain that. Private respondents are above me, whereas in the original merit list, they are below me, my lord. So 16(4) says seniority is to be as per position in merit list, but the impugned gradation list has not maintained that. I am placed below the private respondents who are originally below me in the original merit list, my lord. Now, 16(4), lordship, on the last occasion.
That original position stood altered after the judgment of this bench, isn't it?
As far as the junior level post is concerned. But once promotion comes through.
Now, this 16(4),
yes,
it applies to only junior level post, or
no?
Because the senior members of service,
it applies to the senior level post. In fact, on the last occasion,
it says, if you see by the language, recruited after the commencement. That is where.
After the commencement of the rules, that is in 1970.
Service recruited after the commencement. Recruited.
So
if you say recruited, is it not that the entry at the initial level?
No, my lord. Recruitment means recruitment into the service. I'll just explain this part. So it's a very pertinent question that lordship had asked. If lordship kindly looks at 16(4),
yes,
the wordings are important because the words have been defined in the rules. Sorry. the seniority of the members of the service. I'll just pause a minute. Seniority of the members of the service recruited after the commencement of these rules shall be in the order in which their names appear in the list prepared under sub-rule 4 or rule 6 or approved under rule 8. Now, seniority of the members of the service. My lord, this is a defined phrase, my lord. If lordship kindly looks at the definition, that is rule 2. Rule 2, sub-rule E. First sub-rule G, my lord. Rule 2, sub-rule G.
Yes.
Means service, means the Meghalaya civil service.
Yes.
Service does not mean junior grade, my lord. More importantly, my lord, sub-rule E. Sub-rule E, member of the service means a member of the Meghalaya civil service. Again, my lord, member of the service is not being defined as member of the junior grade. Now, if lordship places this definition in 16.4, the seniority of the members of the service, not the seniority of the members of the junior grade, will be determined by the position in the merit list. So as long as I am in the service, that is the Meghalaya civil service, my seniority will be determined by my position in the original merit list. So the definition of service, members of the service, is important, my lord. It cannot be read, 16.4 cannot be read that the seniority of the members of the junior grade shall be determined as per the merit list. It says members of the service. So during my service life, while I am in the MCS, my lord, my seniority will have to be determined by my position in the original merit list, my lord. Lordship has raised, again interjected pertinently by saying that 2022 Justice Banerjee's judgment, will it not have changed the position? It does not, and that position is very clear. It only explains the position as far as the junior grade is concerned. Now we have gone beyond the junior grade. We are in the senior grade, my lord. So that is number 3, my lord. and this is a question that lordship had asked on the last occasion also of the respondents, but no answer.
Problem is that the
naturally, my lord. Naturally.
Goes
Naturally, my lord. After so long, it's been about 4 weeks now. But point is, my lord, the question had been raised by my lord to the respondents. No answer could be given, my lord. The only answer was that possibly the impugned gradation list, there was a typographical error where it mentions 16, that it's been prepared under 16.4. With all due respect, my lord.
Has this been raised in your writ petition?
It has been raised.
And what is their response so far as the 16.4 is concerned in their affidavit?
My lord, the response is that 16.4 has no relevance after promotion. But very clearly 16.4, what I've just, the definition, etc., very clearly shows that 16.4 is the only relevant.
Otherwise, they stand in the affidavit as 16.4 has no.
After promotions. My lord, lastly, if lordship recalls, I had relied on a few judgments. One was the Supreme Court judgment, very recent judgment of 2024, Ranjit Singh versus State of Tamil Nadu, where State of Tamil Nadu, my lord, was recruiting sub-inspectors from the open market and from in-service constables. So in-service constables who were already in the service were to be given seniority over the open market candidates, my lord, simply for the reason that they were in service before. Similar to our case, because private respondents received their appointment 2 years before, my lord. Now, Supreme Court was very clear in this judgment that when recruitment is done through a competitive exam, the position held in the merit list prepared after the competitive exam is the only criteria on which seniority can be given. Your past service, your seniority in the service, if it exists, cannot be the criteria. Your position, your performance in the exam will be the only criteria. That being the case, my lord, my performance in the exam was above private respondents. Therefore, my lord, seniority has to be in my favor. In my favor. That was the Supreme Court judgment. Then the division bench judgment of this Honorable Court, Crispilla T. Sangma, where my lord was also a part, has held more or less the same thing. That seniority in service cannot be of any assistance. It is the position or the performance in the competitive exam post which a merit list is prepared. Your position in the merit list will be the only defining, guiding criteria. Lastly, my lord, again, division bench judgment, the roster case of this honorable court, where again the same thing had been stated, that simply because of the roster, you may have received appointment prior to somebody else, but that will not determine seniority. That will not determine seniority. Your seniorities will still be determined on the basis of applicable rules. Applicable rules in this case is 16(4). So that is the brief summary of my case. I will seek Lordship's indulgence to respond to some other aspects that may come out from the respondents, my lord.
Yes.
This is your Lordship. Lordship, the case here, the issue here is not does not relate to the promotion as advanced by the petitioner, your Lordship. The issue here is relates to the accreditation list, your Lordship. Kindly come to the prayer, Lordship. If Lordship kindly have page 21.
Yes.
Lordship, the relief claim in the writ petition is done 2, your Lordship. Roman 2, your Lordship. Upon cause, if any, and upon hearing, be pleased to set aside the letter that number dated 17/1/2024 issued by the Personnel and Air Department, Government of Meghalaya, and further be pleased, Lordship, kindly see, Lordship, be pleased to direct the respondent to revise the accreditation list of 22/8/2022 in accordance with Rule 16(4), 22, and 23 of the MCS rule. Lordship, this issue, your Lordship, revival of this accreditation list, your Lordship, that has been dealt by the in the earlier writ petition, your Lordship.
So it is hit by res judicata.
Lordship, yes. Lordship,
22/8/2022 was the subject matter in the.
No, your Lordship. The 22/8/2022, your Lordship, this list was prepared, was revisited by the government in view of the judgment passed by the landed single judge.
It was,
Lordship,
yes,
then
it was done as per direction of the High Court.
Lordship, if Lordship kindly have, then Lordship kindly have the affidavit filed by the state. If Lordship kindly have page 101. Before that, your Lordship kindly have Lordship kindly have the state affidavit, the Lordship.
1 minute, Mr. Shura, just a minute.
Lordship.
You have also filed any written notes of your argument, no?
No, your Lordship, I'm yet to.
Then please give it. So
Yeah, certainly, I'll do that. I'll do that, your Lordship.
minute points will be.
Yeah, I'll do that, your Lordship.
Yes, please.
If Lordship kindly have a page 35, that is the earlier writ petition, your Lordship, filed by the present private respondent, your Lordship. And if Lordship kindly have a page 57, the relief claim in those writ petition. 57, your
You are
Lordship.
referring to your affidavit.
Lordship, yes. Lordship kindly have page 57. And Lordship kindly turn page 58.
Wait, Mr. Shura, just a minute.
Page 57, your Lordship.
You are 1 and 2. Respond number 1 and 2.
Lordship, yes. This is the affidavit filed by the Personnel Department, your Lordship. 1 and 2. Correct, your Lordship. Page 57, your Lordship.
Yes.
Lordship has gotten.
Yes.
Lordship kindly turn to page 58. Then Lordship, if I may read, Your Lordship,
Yes,
in the
please.
earlier writ petition,
Yes.
in the premises aforesaid, it is most respectfully prayed that Your Lordship would be graciously pleased to issue rules, call for the records, and after hearing the parties, be pleased to set aside and quash the accreditation list published on 20th June 2014 by memo number so and so. Lordship, I am taking Your Lordship to that 20th June 2014 accreditation list. Lordship will kindly come to page 101. Lordship, this is the notification dated 20th June 2014, the accreditation list, Your Lordship. Lordship kindly then come the petitioner, Your Lordship. Lordship kindly have page 113. Where are the writ petitioner? Lordship, the writ petitioner are at serial number 31, the lead petitioner. Serial number 31. Lordship has got it. Bayan Timon Bla. Lordship has got it. Page 113, Your Lordship.
Yes.
Lordship kindly have 113. Lordship kindly have serial number 31.
Yes.
Shrimati Bayan Timon Bla. She is the lead petitioner. She was the private respondent in the earlier writ petition. And then Lordship kindly come page 114. Where are the private respondent here, Your Lordship? The present private respondent. Lordship will find it at serial number 51.
Yes.
51, 52, 46, 47, Your Lordship, page 114, Your Lordship, 46, 47, 48, 49, 51, 52, 53, on this here.
7.
Lordship. So, Your Lordship, in the earlier round of litigation, Your Lordship, in the accreditation list of 2014, they were above the present private respondent, Your Lordship. That was put in challenge, Your Lordship, by the present private respondent before this honorable court, Your Lordship. And Lordship, that judgment, Lordship, done then by the judgment. Lordship kindly have a page 212. That is the judgment of the then Honorable Chief Justice.
Yes.
Lordship kindly have a para 22. Writ petition number 301, 302, and 306 of 2018, 219, Your Lordship.
Yes.
219 are allowed. So allowed, that means that accreditation list, Your Lordship, of 2014, in which the present writ petitioner were above the present private respondent, have been revisited, Your Lordship.
And that 22-8 list was prepared after this judgment was heard.
Lordship. And then if Lordship kindly come to page, Lordship kindly bear with me. Lordship kindly come to page 77 of the writ petition. I'm sorry, Your Lordship, for taking Your Lordship from the writ petition then to the affidavit. Lordship kindly have page 77 of the writ petition. These are the representation, Your Lordship. Lordship, these are the representation submitted by the lead petitioner, Your Lordship, Annexion 9, page 77, Your Lordship. Lordship, whether Lordship is with me.
Yes.
Then Lordship kindly have page 81 or page 81, that is Annexion 10. This is the representation, Your Lordship, of the lead petitioner. Kindly see the date, Your Lordship.
How many petitioners are here?
Lordship, here, how many? Only one.
Okay.
Only one. Kindly see the date, Your Lordship. Kindly
So
come.
there are a number of writ petitions.
Lordship, yes.
Then
If
this list which you have pointed out
Lordship.
earlier, the senior list,
Lordship.
which was challenged, you have pointed out only to the name of the petitioner of this case. Yes.
Lordship.
Others are also above the where.
Yes,
above.
Your Lordship. Yes, Your Lordship. Lordship, kindly come back to page 80. The date is very relevant, Your Lordship.
Page 80.
Page 80, Your Lordship. Lordship, on the left side, Your Lordship, if kindly see the date.
September 20. 20th September.
20th September 23.
Yes.
And then Lordship,
22. It is 22. See.
oh, I'm sorry, Your Lordship, 22, Your Lordship. I'm at, then Lordship, kindly have page 84 of the writ petition, Your
These
Lordship.
are all his representation.
Lordship, yes. Lordship, I'm pointing out the date, Your Lordship. The date is very relevant, Your Lordship.
20th October 2023.
20th October 2023.
Yes.
Kindly see, Your Lordship, the date of the judgment passed by the then Honorable Chief Justice. That was the judgment of 10/2/22, Your Lordship. 10/2/2022, Your Lordship.
Yes, before-
After the judgment, Your Lordship, they filed this representation, Your Lordship, for rearranging the credition list, Your Lordship, after the judgment, Your Lordship. They were happy with the judgment, Your Lordship. They were happy. They were happy.
No, this judgment, so long it is not challenged, then it
It
stands.
remains, Your
Whether
Lordship.
they are happy or
So it is
unhappy.
the writ petition, in my humble and respectful submission, Your Lordship, is hopelessly barred by the principle of res judicata, Your Lordship. Lordship, kindly have page 85, Your Lordship. I'm sorry, Your Lordship, for not pointing out page 85, Annexure 11, the
Yes.
rejection order passed by the government, Your Lordship.
Yes.
Kindly see, Your Lordship. This is from the Undersecretary, the Government of Meghalaya, Government of Personnel and the ANAR Department. Lordship, it has been addressed to the lead petitioner, Your Lordship. Kindly see the reference. Credition list by notification. With reference to your representation on the subject cited above, I am directed to inform you that the credition list 22A-22 is in continuation of the credition list published on 4/3/22 in portion of the High Court judgment 10/2/22. Your Lordship.
So that means this petition basically is seeking alteration.
Lordship, yes,
of the
revisit.
position
To
which was
revisit, Your
erected
Lordship.
pursuant to the judgment of
Your Lordship, in fact, in my humble and respectful submission, Your Lordship, the writ, all this series of writ petition are in the review in the sky, Your Lordship. Review in the sky, Your Lordship. To revisit the judgment passed by the then Honorable Chief Justice, Your Lordship. Which cannot, Your Lordship.
But then what about his contention with regard to the rules 16.4 and all, application of rule 16.4 and all?
Lordship,
Then
Rule 64 says so, but Your Lordship, but government cannot,
But then you have
the government, when there is a judicial direction, Your Lordship, a judicial order, the government is bound to comply with that. If we don't comply with that order, the government will face a contempt, Your Lordship.
Is it not that it ends moment all of them were promoted to the senior grade? The position which was required to be maintained pursuant to the earlier judgment of the earlier end of litigation, that situation remains so long they are in the junior grade.
Pardon, Your Lordship, I couldn't.
The position of seniority
Lordship.
in terms of the judgment, earlier judgment of the court between the same parties,
Lordship.
basically speaks about their position with regard to the junior grade post, isn't it?
Lordship.
Now, when they are promoted to the senior level or senior grade, whatever you say, whatever it is.
The seniority is
Whether-
taken from that list only.
So, but then whether that is to be maintained again, or you see, like that, another separate serial notice has to
Lordship, here
prepared in terms of 16.
here, in my humble and respectful submission, Your Lordship, the question of promotion does not arise. The issue which has been raised relating to promotion does not arise because there was no challenge to the order of promotion which has been issued to the private respondent here, in Your Lordship. That is the order dated 7/3 to 7/3.
That is a part of record. You have brought it in the record.
Lordship, yes.
And then now what happens after the promotion is made? Then which way seniority is fixed there? That is again on the basis of their.
And that is on the basis of the rule seniority basis, Your Lordship. There is a judgment of the Honorable High Court. That judgment will bind the state government as long as that judgment is not reversed or set aside by the appellate bench. We cannot ignore, Lordship. We cannot ignore this judgment of the then Honorable Chief Justice.
There is no question. Whether judgment loses its relevance or not, that is what is to be decided. If that's the direction made in the judgment remains, then position cannot be altered.
Yes. Lord.
Now, the submission of Minter Jindal is that this judgment of the single bench, the earlier round, loses its relevance once the.
No, Your Lordship. No.
Once the petitioner and the respondents are promoted to the senior grade.
No, Your Lordship. It will go on, Your Lordship. Because, Your Lordship, the issue of promotion here, it does not arise, Your Lordship.
Then what do you say about invocation of 16(4) again? See, even after they were promoted to the senior grade, you have prepared a senior list in terms of 16(4). Now, whether if you prepare it, the provision of 16(4) can be ignored or not.
Lordship, because as I have submitted, Your Lordship, there is a judgment. The judgment of the Honorable Court may be right, may be wrong, Your Lordship. And the authority is bound to obey, Your Lordship. Is bound to obey, Your Lordship, until and unless it is reversed or set aside, Your Lordship. So this is what the state government has done in the present case, Lordship.
There is no dispute to that proposition of law.
Lordship.
Now, what this court is asking you, basically, has been the contention of Mr. Jindal about the preparation of seniority list or gradation list insofar as their
promotion is
in
concerned.
The promotional post is concerned.
Lordship, that it will follow. It will follow from
what
the.
basis?
It
Whether
will follow.
It means
from the gradation list dated 22/8/22.
Are you trying to say that their seniority in their in the post
Promotional post.
that is a permanent position and it is not subject to any alteration.
22A, Your Lordship. Seniority.
So this cannot be altered. Even in
Lordship,
future
yes.
posts.
Yes, Your Lordship. And the letter issued by the government to the lead petitioner is very clear, Lordship.
It is not dependent even if all of them are not promoted at the same time. Their position, so far as the seniority is concerned. I do not know whether the court is able to communicate to you or not. See, what the court is trying to communicate means, according to you, that the seniority which is maintained in the position when they are first recruited, taken into service,
Lordship.
whether that seniority position remains intact.
Yeah, it will
even
remain.
for.
Yes, it will remain, Your Lordship. It will remain. There is a gradation list. So that list will have to be maintained, Your Lordship. Even
So it is not subject to any alteration.
No, Your Lordship. Even for the future promotion. As I have submitted.
If what happens if some of any one of them is promoted? Say suppose if a junior in the original grade is promoted to the promotional grade before the senior, then will he not become senior in the.
Lordship, let us, my humble and respectful submission, let us not foresee that, Your Lordship, because if that issue arises, Your Lordship, somebody will come again and approach Your Lordship.
For the purpose of understanding, not for anything. Now you say that this position of seniority is not subject to any alteration.
Because
whatever senior position of seniority is there in the original post, that will be maintained throughout.
yes, Your
That
Lordship.
is what you are saying. Okay, so that means once a seniority position is resettled after the judgment of this court,
Yes.
this is not
That
subject
remains,
to
Your Lordship. It
alteration.
remains. It remains.
That will hold forever.
Yes, Your Lordship. And kindly appreciate also one thing, Your Lordship. In those earlier writ petition filed by the present private respondent, the writ petitioner here, they were made private respondent in those earlier litigation, Your Lordship.
That's all right. That's all right.
They have not. They have not. This judgment, Your Lordship, 10 to 22.
That is
I
okay. It
think
is
it's
not
finality,
the
Your Lordship.
contention of Mr. Jindal that the judgment will not bind him. He said it will definitely bind him. But then so long he remains.
If it is binding, Your Lordship, then the contention of the state, Your Lordship, is that it is barred by res judicata. Is correct. Is lawfully correct, Your Lordship. There is no question of Lordship revisiting or re-agitating the issue which has already been dealt with.
Okay. Anything more you want to say?
That is my submission, Your Lordship.
Please give us a written notes of your thing.
Lordship, I'll do that,
Whatever
Your
the
Lordship.
points you want to refer.
Lordship, yes.
Okay,
I'll
the
do
page
that,
number,
Your Lordship.
please.
Lordship,
Yes.
if I may permitted, Lord.
Yes, you'll be. Why not? You are a party. You have a right. Huh? Isn't it?
Lordship, now what we can understand from the
Yes.
submitted advance by,
You filed your affidavit.
we have filed an affidavit, Madam, is that the judgment of 10 to 2022 loses its credibility and applicability after promotion has been accorded, Madam. Madam, that is
What has been. That is the summons
Yes,
of
Madam.
the case.
So before going into Rule 16.4, why Rule 16.4 will not be made applicable to the petitioner herein is because, my lord, we have to go into the backdrop of the case, my lord. Why the case was initially filed. Lordship, the case was filed because the respondents herein, my lord, were appointed way back in the year 2010. They were appointed in the year 2012.
So that is the reason why
Yes.
the seniority position
No,
was not-
the
that court has. Court
yes,
has
my
not-
lord, but I just wanted to clarify, my lord.
Just tell us about 16.4.
Yeah,
Application
my
of
lord.
16.4.
Before coming into that, my lord, I just wanted to clarify.
Okay.
So 2010, my lord, there were only 10 posts or 40 posts, my lord. After 40 posts was already filled up, there were no more vacancies, my lord. The vacancies came only in the year 2012. So Supreme Court has held that once 40 posts is already filled up, the list, the earlier list, merit list becomes exhausted, my lord. That is why, my lord, in the year 2019, my lord, 2019, a single judge, my lord, passed an order in their favor, my lord. So we approached the division bench, my lord, challenging that order. That order, my lord, lordship will find in my
There are how many rounds of litigation before?
the multiple rounds of litigation, my lord.
No. So far as the issue of seniority or gradation
Yes.
list is concerned, how many rounds of litigation?
Only once, my lord, it was decided, but in the year 2019, the single bench passed an order in their favor, my lord.
Earlier decision
Yes.
referred to by Mr. Shulai, was it
Yes.
a single bench decision? This is a single bench decision,
Yes,
isn't it?
single bench decision.
Yes.
No, I just wanted to clarify as to what has happened, my lord.
No,
Just
if,
for the
if you
knowledge,
go
my lord.
back to that
No,
extent,
no, my lord, this is very pertinent, my lord. This is very pertinent. Why I'm going back to that, my lord? Because why I want to say that 16.4 will not be made applicable to them. That is the main issue here, my lord. So that is why. That is the reason why I wanted to go back, my lord. Without going back into the history, my lord, we cannot determine as to why 16.4 is not made applicable to them. So, my lord, if lordship comes to page 29, or page 39 of my rejoinder, so affidavit in opposition, my lord. This is the order passed by the...
Your respondent number?
My lord, here we were the appellant, my lord. I am here, I am respondent. I am appearing for 10 respondents, my lord, hearing.
No, in this present case, you are referring to your affidavit. You have to find out your affidavit.
Yes, yes, yes.
3, 5,
3, 5, 6, 7, 8.
and 10 to 15, isn't it?
Yes.
Your affidavit is dated 19/7.
Yes, my lord. Page 30, my lord, will be the relevant.
Page
This-
30.
Yes. This is the judgment rendered by the division bench, my lord. If lordship comes to para 16. Another observation of the learned single judge that merit has to be given priority that cannot be denied. But when only 40 vacancies were available in the year 2010, same have been filled up, and in case no other vacancies would have accrued, then the candidates appointed in 2012 had no chance of any appointment. They appear to be chance beneficiaries, my lord.
No,
This-
that is okay.
this
That
was
is-
the-
that is the position of law. That is
Yeah,
all right.
that is the position of law, my lord.
But
Thereafter,
then why you are referring to this? Was it passed in that in relation to that single bench order? No.
yes, thereafter, my lord, I will refer to the
No, just
judgment
a
which.
minute. Just a minute. This judgment.
Yes. No, after this, my
Concerns
lord,
what? What
this
also
after this judgment was rendered, my lord, it was again remanded back to the single bench. The single bench, my lord, after going through this judgment and after looking to records, my lord, has passed the judgment of 10/2/2022, which was delivered by the Chief Justice, my lord. So, I would like to bring the relevant portion,
This
my
is a
lord.
2019 judgment.
Yes, my lord. So why this is relevant? 16.4 is not applicable, my lord, because
We do not have to go that far. See, the position so far as the appointment, the junior grade is concerned, that's to finalized by the single bench order.
yes, my lord.
Okay. Now, only thing is that what we want to know,
No, 16.4,
that
my lord.
what determines the seniority when they are, all of them are promoted to seniority grade.
That will be on the basis of the earlier gradation.
Just show us that. See, that is what, because 16.4, you say 16.4 will not be applicable.
So far as they are concerned, my lord.
If 16.4 is not applicable,
Yes.
then which rule will guide preparation of gradation list?
16.4, so far as those candidates or those employees, my lord, who have been appointed on regular basis, my lord. Their appointment itself was not even regular, my lord. Their appointment was questionable, my lord. That is the reason why in the judgment.
Where you are taking us? Are you now challenging their appointment?
No, that is the reason why. That is the reason why 22 has referred that matter, my lord. I'll show you, my lord, the relevant point where the learned single judge has
Yes,
stated that particular point.
Mr. Shulai, is there any issue with regard to the regularity of appointment of the petitioner?
No, Your Lordship, that was
But
not
then
put
Mr.
in
Momin is
question.
taking us to
Even
that.
in the earlier round of litigation, that was never questioned, Your Lord.
No,
that was
my-
not
my-
the issue, Your Lord.
Lordship, kindly bear with me, my lord.
No, you see, where court is there. But then the thing is that it confined to the subject matter in issue.
So that is what, my lord.
Why you are going to all those issues? You see, forget about whether their appointment was on regular basis or not, their chance beneficiaries or not.
No, that is-
It has no application right now.
No, that is why, my lord, the single bench has held in 2022, my lord. I'll just place that particular paragraph. In my rejoinder itself, my lord. Page 41.
Your affidavit in opposition, not
Yes.
rejoinder.
No, sorry. Affidavit in opposition, my lord. Page 41. This is the judgment rendered by the single bench, my lord. Para 9, my lord.
What is this judgment?
This is the judgment passed by the single bench, my lord, which they have not challenged. Now they are saying that this, so far as this judgment is concerned, it does not affect them, my
That is
lord.
the judgment which Mr. Shulai also has referred
Yes,
to.
yes, my lord. I'm just relying on this paragraph 9, my lord, page 44.
Yes, please go ahead.
Paragraph 9, my lord.
Yes.
The private respondents came to be appointed on or about 8 of 2012 from among the leftover candidates who had been appointed in the year 2010. Again, the principle of reservation was applied and the candidates were appointed according to their merit. It transpires that in 2012, a seniority list was prepared, and in such list, the persons recruited in the year 2010 and the persons recruited in the year 2012 were clubbed together for determination of inter se seniority among them. This was patently absurd and completely without any element of rationality or logic. It is elementary that an inter se seniority list assumes that all the persons in such list were appointed simultaneously, whether on the same date or in the course of the same exercise. A person who has been recruited or appointed earlier in point of time that another in the same post can never be equated with the persons appointed later, even to the same post. The very need for preparing an inter se seniority list arises upon a number of persons having been recruited to the same post simultaneously or by the same process. It bears repetition that if several candidates have been recruited or appointed to the same post on the same date or in the same course of same exercise, only then they would be inter se seniority need to be determined on the basis of criteria which are fixed thereof. And kindly come, my lord, to page 46.
What follows from there? That number, paragraph number 10, reading of number 10.
It says it should be from the same exercise, my lord. If lordship sees, it bears repetition if several candidates have been recruited.
The preparation of inter se seniority list
Yes.
is confined to the persons
Yes.
who were recruited
Yes. In the same.
simultaneously or out of the same process.
Yes.
So that means any other person
Yes.
remaining or working in the same position,
Yes.
though has not been recruited by the same
Process.
selection process,
Yes.
cannot be a part of that inter
No. Yes. Yes, my lord. That is what I'm trying to say, my lord. That is very pertinent, my lord. That is why the number of judgment which my learned senior has placed, my lord, saying that merit list shall prevail. The proviso is that it should be from the same selection process, my lord. If it is not from the same selection process,
So
then
it means,
they cannot.
it means,
Yes.
so suppose in a department there are 20 persons
Yes.
working in one post in the,
Yes.
and then, but then they all have not come from the same recruitment process and they were not appointed simultaneously.
Yes.
So it means there should be some different
Yes.
inter se seniority list.
No, but the criteria will be different for them, my lord. The criteria will be different for them, my lord.
Criteria is a different thing, but then
Yes.
see, like if we, that is why you see, like this court wanted to understand what proposition follows from reading of this paragraph 10.
It means that the person, the merit list, my lord, will only be applicable if they are recruited from the same selection process, my lord. Because the merit list, that is what I'm trying to imply, my lord, that the merit list becomes exhausted once that 40 candidates is appointed, my lord. They were not part of that 40 posts, my lord. Not 40 candidates, my lord. They were appointed later, much later, my lord. That is why, my lord, the single bench, while passing this order, has made the proviso, my lord.
Okay, in such list. Okay, yes, all right. Yes, you're correct. Yes. Yes,
That is why, my lord, I kindly come to page 46 now, my lord.
in such list. That is what is not been.
Yes. And there are plethora of judgments to that effect, my lord.
See, that the fact remains that they have to come from.
Same selection process. Yes. So that is why I'm trying to imply, my lord, that 16.4 will not be made applicable to them since they are not from the same selection process. And that is the reason why, my lord, page 46, para 16, my lord, if lordship comes.
But even then, confusion reigns.
Lordship? No, I'll come to what lordship is really want to know, my lord. But before that, my lord, I'm just coming to that, my lord. Kindly come to para 16, my lord.
The court is not getting basically what it wanted. They about the preparation of inter se seniority list.
No, about that rule 22.
Especially in reference to what has been said in this paragraph 10. Anyway, all right.
Lordship, kindly come to para 16 now, my lord. Para 16, my lord.
Yes.
The seniority in a particular post in sense indicates who had occupied the post earlier. The need for determining the inter se seniority arises when several persons are appointed to the post simultaneously on the same date or in course of the same exercise. Such determination may be necessary for future promotion. When the two sets of appointment are so distinct and different in points of time as in 2010 and 12, there is no question of apples and oranges being put in the same basket for the inter se seniority or two completely distinct classes of persons to be attempted to be ascertained. The state government should have known better, my lord. Here he has completely distinguished, my lord. The appointment made in the year 2010 and the appointment made in the year 2012. That is why the single judge, while was giving an example of apple and oranges cannot be put together in the same basket, my lord. Because court, in view of that earlier division bench judgment, and after going through the records also, my lord, has come to a finding, my lord, that they were not out of the same selection process, my lord, same exercise.
So this basically this observation comes in view of that.
In view of that judgment as well, yeah. Yes, my lord.
Division bench judgment.
Yes. And 2000 latest.
Otherwise, they all are either apple or oranges, isn't it? Minus that observation of division bench.
Minus their observation also, my lord, they are still not under the, cannot be in the same, under the same basket, my lord. That distinction has been made, my lord. That plethora of judgment to that effect as well. And here, my lord, if I go to the rules also, the validity of the select list is only for 1 year. The validity of the select list also goes.
Go on, forget about that part.
Yes. Now, my lord.
Legality or illegality of their appointment, it is gone. And it is not for you to question it.
No, that is what, my lord. Now, in view of this judgment, my lord, a gradation list was prepared, new gradation list was prepared, wherein we were placed above the petition.
But then is it not the clubbing together of orange and apples again?
Yes, the reason why, because now their appointment cannot be cancelled, my lord, because we did not challenge their appointment also. But court has observed.
So that is where again that the proposition of paragraph 10 comes into question.
No, because in many of the cases, my lord, in the recently also this judgment of the judicial officers also, the court held that their appointment is questionable, but still then, my lord, they were appointed. And their appointment was not cancelled, my lord. There is a latest judgment, my lord, your lordship is aware. And the law also prescribes that the validity of the select list is 1 year only. After 1 year lapses, my lord, their appointment becomes illegal. But here we are not questioning their appointment, but so far as seniority is concerned, my lord, what I'm trying to imply is that, my lord, that after this judgment, a new gradation list was published, my lord. They did not challenge that gradation list. After that...
What is the question? Because that was prepared as per the direction of the High Court.
Yes. Then after that, a promotion was accorded, my lord. Now I'm coming to that rules, my lord.
You need to address the court on that.
That
what
promotion.
happens after promotion?
The promotion, the MCS rule which they were relying on, that is an incomplete rules, my lord. I'll just show you one rule, my lord.
It is incomplete.
It's incomplete, my lord, because there was another notification to that effect wherein para 3, rule 22, para 3 was inserted.
My lord, sorry to interrupt, my lord.
Yes.
This is beyond the pleadings, number one. And number two, my copy cannot be read.
No, there is a type copy to it. This is a type copy.
But it's beyond the pleadings. It's not part of the affidavit.
No, but then it's
No, because he's going beyond his own pleading, my lord. He's saying about the promotion, my lord. That is where I'm going.
We'll give you time to respond to it. That's simple.
So here, my lord, Rule 22, sub-rule 3 says, the appointment of MCS officers to the heads of department level shall be made by the governor from amongst the members of the service.
Department level, or what is that?
Amongst the members of, leveled, shall be made by the governor from amongst the members of the service in the senior scale and screened by the screening committee.
What is that level means?
Same level, my lord. Senior level, my lord. Senior level, my lord. Promotion to senior grade time scale, my lord. They have been relying on this same rule only. Here it says, my lord, The appointment of MCS officers to the heads of
Is this word appears to be correct, Mr. Jindal? This the appointment is head of the department level.
No, it should be. My understanding is appointment of MCS officers to the heads of department
level.
So that is where the confusion is. So
What if this is the rules, my lord?
rules we have a copy.
No, that one is incomplete one, my lord. This is the
So
complete.
this is after this amendment. This
Yes,
amendment has been
after this
incorporated
amendment.
here. in
Yes,
the
yes, it has been incorporated, my lord. That's why I'm furnishing that rule, my lord. 22.
This amendment has been
These are
incorporated.
incorporated, my lord. 22. Sub rule 3, my lord.
Just a minute. Just a minute.
Yes.
Rule 22.
Rule 22, sub rule 3, my lord.
Please supply Mr. Jindal.
No, I've
also
already
a copy.
supplied.
You are not aware of this amendment, Mr. Jindal?
No, my lord. And it has no application to me. I'll show how. I've gone through it just now.
Okay. Yes.
So the appointment of the MCS officers to the heads of department level shall be made by the governor from amongst the members of the service in the senior
You
scale.
are reading for which one? The
No, that is the same thing, my lord. That's the same thing.
no, you are reading which one? The rule which you have supplied just now, or the
That is the same thing, my lord. The contents are the same.
you are reading rule 22(3).
Yes, rule 22(3). It should be level, not level, my lord. It should be only level, my lord. It's typographical errors there. The appointment of the MCS officers to the heads of department level.
Here, your xeroxing is such the lines are not.
Yes. No, but that notification is there, my lord. I've just given you a type copy as well.
Okay. Yes. Yes, please.
In the senior scale and screened by the screening committee, departmental promotion comes on the basis of merit with due regard to seniority, my lord. So seniority was accorded, the promotion was accorded in regard to seniority, my lord. Now they are not aggrieved by that promotion order, my lord. What earlier they were trying to imply was that Rule 16(4) will be made applicable once seniority has been accorded. That was their contention, my lord. But here the promotion itself is basing on the seniority, my lord.
Mr. Jindal's submission is that the very order by which you have fixed the seniority has been passed under 16(4). That is what, and that is why this court is asking for clarification from you, from Mr. Shulai,
I may.
about application of 16(4), because initially this court had confusion whether 16(4) will be applicable to the promotional post or not.
Lordship, that has
But then-
been-
Yes.
If I may
But
interrupt
six-
your lordship. If I may interrupt your lordship.
Yes.
In fact, that has been dealt by in the judgment of 22, your lordship. If lordship kindly have come to the affidavit filed by the state again, your lordship.
Anyway, Mr. Shulai, you just address it in your thing. We'll just see it.
Lordship.
We'll not disrupt Mr. Moment right now.
Lordship.
Let him go. Yes.
So what I'm trying to imply is, my lord, that once promotion has been accorded on the basis of this particular rule, which says that seniority should be made applicable, my lord, they were not aggrieved by this promotion. And after that promotion was accorded, another gradation list was published. Now they are aggrieved by that gradation list, saying that 16(4) will be made applicable, which says that merit list should be prevailed, my lord. But it was already dealt with, my lord. That is the reason why 16(4), so far as they are concerned, will not be made applicable to them. That is my contention.
So when promotion is not under challenge, there cannot be challenge to this.
Yes, because
That is the sum and substance of your saying.
Yes. That is my case, my lord. And the judgment which they have relied, my lord, Crispilla T. Sangma also, I was the one who was appearing in that matter. I was the petitioner, my lord. There also, my lord, the case was dismissed because we had made a categorical statement in the representation that we are not aggrieved by their promotion, my lord, or by their seniority. That is the reason why in the appeal it was dismissed, my lord. But the problem in that matter was that was out of the same selection process. That is the reason why the merit list had to prevail, my lord. But in this particular case, the merit list cannot prevail, so far they are concerned, my lord, because their appointment itself was not out of the same exercise. If had it been out of the same exercise,
stands decided. We are not going into
Yes.
that question again. So far as it is not at all required also, not relevant for purpose of determining the issue which is raised here.
okay. Watch it.
Why you are repeatedly harping on that? That just to term that like their appointment was not from the same list or these things. You say we are not on that. The fact remains that they have been taken into service.
Yes.
They have been given promotion.
Yes.
And their seniority also has been fixed in accordance with law.
Yes.
In pursuit of the judgment of the High Court. So what is the question of
No, but
challenging
my
the legality of their appointment?
my contention is 16.4 will not be made applicable to them. That is my contention only, my lord.
So that is what you have to say clearly, 16.4. Then which way you will explain why 16.4 has been referred in that impugned thing?
16.4 will only be referred for those persons who were appointed on the
Come to that thing.
same
Have you seen
same appointment, my
Have you
lord.
seen whether the present case, the order impugned where it is?
Which order impugned, my lord?
The order which has been impugned here in this case, in this petition.
Page 66, my lord.
See how it starts. Read it.
The provisional gradation list of the members of the Meghalaya Civil Service as per Rule 16.4.
So, what you will say there? 16.4 has been invoked here.
Because that is where I'm coming to my point only, my lord. Now, since their appointment was not cancelled, now they were inducted. No, they have to be there, my lord. 16.4 is the rule, basing on those persons who have been appointed. The appointment was not questionable for those. Then only 16.4 will be applicable, my lord.
So
Now-
your case is that 16.4 is applicable. Forget about the what should be or not. But then 16.4 is applicable.
Yeah, because their appointment stays. Now, because of the judgment, now they were made junior to us. Now they cannot go on time and saying that 16.4 should be made applicable to them on the basis of that earlier merit list, which has become exhausted, my lord. That merit list becomes exhausted. So they are harping on a merit list which is no more valid, which is no more in operation, my lord. Even if 16.4 is made applicable to them, that merit list, they cannot harp on that merit list, which has become exhausted.
You just tell us what you say. 16.4 is applicable. It should not be a
This is a rule,
hypothetical
madam.
kind of submission that even if 16.4 is applicable, that also will not give them any benefit. All right, reviewing about just say 16.4 is correctly quoted here. It is applicable here, or some other rule will be applied.
No,
apply here.
because so far as gradation is concerned, 16.4 is made applicable. That is my contention, my lord.
That will so it is made applicable. We can see, but
Yes.
then, and that will apply. So it's correctly applied.
Yes, it's correctly applied, my lord. So far, this 22 August 2022 gradation is concerned, is correctly applied. In view of the judgment, my lord, rendered by the single bench, my lord.
You see, you are stretching, going somewhere. The court question is only confined to that, whether the reference of 16.4 in this notification dated 22nd of August. This is 22nd August is what? With regard to the seniority?
Seniority.
In the,
Gradation list, my lord.
no, in which? In promotional post, in the original post?
Promotional post.
In the promotional
Yes.
post. So this court question is that whether 16.4 will apply to the promotional post.
Yes.
Your answer is yes.
Yes.
Yes. And where this 22 will apply? Rule 22?
In the promotion, my lord. in the promotion.
16.4 also will apply, 22 also will apply for fixing seniority.
No, that is, on that 22 rule, my lord, is fixing promotion, my lord. That is for promotion. 22 is for promotion, my lord.
So 22 is only for the purpose of promoting, not for fixing seniority.
But they have not challenged that promotion, my lord. What I'm trying to imply is that because promotion is already accorded in view of Rule 22, that has not been challenged. Now they cannot be aggrieved by this gradation list, my lord. They are not aggrieved by the promotional order, my lord. So once promotion has been accorded, now they cannot be aggrieved by this gradation list, my lord. It's like bypassing that particular promotion order. They cannot pick and choose what they have to challenge, my lord. That is my contention. (22) says, my lord, promotion to senior grade time scale.
Where this Rule 6.4 applies?
16.4, my lord.
6.4. Look, sub-rule 4 of 6, of Rule 6, deals with what?
Meritless.
It's meritless, my lord.
Of what? Of which post?
For the MCS, my lord. Recruitment for competitive examination. In the merit list.
Whether it has any application so far as the promotion to the senior grade is concerned.
No, once that it becomes exhausted, my lord.
Please give us written notes. See, like, I do not know, its submission appears to be very, very confusing. Submission appears to be very confusing.
22, Rule 20 speaks about promotion, my lord. So promotion was based on seniority.
Please read this 16.4 and just explain us what it says.
16.4 is the seniority of the members of the service recruited after the commencement of this rule shall be in order in which the names appear in the list prepared under sub-rule 4 of Rule 6.
Yes.
So they were not even born in that Kedar when this rule was made applicable.
List is what? Sub-rule 4 of Rule 6 is a list of what?
Recruitment, my lord.
You give it in writing. You give your notes of argument. Have you concluded, or do you want to say something else?
No, that is my only submission, my.
Yeah, please give your written notes.
Can I make two quick responses, my lord? One, two.
You have finished this, say, Mr. Shulai also, you have
Lordship, so far, I made this is your lordship. So far, that Rule 16.4, your lordship, that has been dealt in detail by in the earlier judgment.
That is the crux of the issue. Instead
Lordship,
of going here, there, and all, just explain that part.
If lordship kindly come to that.
Mr. Jindal's submission in a nutshell is that the single bench judgment has lost relevancy once these people are promoted to the senior grade. And in senior grade, once you prepare, just let the court finish. Just wait. Once a gradation list of senior list is prepared in terms of 16, by invoking 16.4, then the provision of 16.4 should be applicable. That is your argument.
Lordship kindly see a lordship.
That 16.4 basically comes in favor because his position is higher in the merit list.
Lordship, what is the challenge in the Lordship will have to see what is the challenge in the writ petition.
See, this submission has not been responded the way it should have been.
What is the challenge in the writ petition? What is the relief claim in the writ petition? The relief claim in the writ petition is that
reconsideration of list of 22
Lordship,
which is not permissible.
Yes, your Lordship. It is not permissible, your Lordship, because there is a judgment. There is a judgment, and in that judgment, that Rule 16.4, your Lordship, at Para 10 has been dealt. In Para 10 of that judgment, your Lordship, Rule 16.4 has been dealt by the then Honorable Chief Justice.
What you will say, whether the quotation of 16.4, Rule 16.4, in that
in that
order is correct.
order
or
of
not?
22.8 22, Your Lordship.
22.8 is promotion in the sorry, seniority in the promotional
22.8 22 is the accreditation list.
of the in the senior.
Yes,
in the
they want
promotional-
to, Lordship, a revisit of that accreditation list.
And wait, just a minute. Bit confusing is that. When was the single bench order was passed?
Lordship, that 10 to 22, Your Lordship.
And when thereafter the seniority revisited thereafter, when, what is that?
7th March, I received promotion.
Lordship,
7th
that
March. Same year. 10th February was the single bench judgment. 10th February was single bench Justice Banerjee's judgment.
Lordship kindly have that
7th March, I received promotion.
kindly have the Lordship.
That is 2nd March of same year.
7th March.
Of same year.
Same year. Few days after the judgment.
Lordship kindly come to page 85, Annex 11 to the writ petition.
Just a minute, Mr. Shulahi, just a minute.
Lordship.
7th March is promotion. That means, according to you, this judgment lost its relevance once you were promoted.
7th March.
So, the preparation of that list
Yes,
on 22/8 could not have been done by following that.
cannot. And evidently, on the face of it, it's not. It hasn't followed the judgment, it has followed the rules. Claims to have followed the rules.
Lordship kindly see. Lordship kindly see, Your Lordship, page 85. Because that accreditation list of 22/8/22, Your Lordship, will have to be read along with this judge, with this
We are referring to
ground of
page?
rejection.
Page?
Page 85.
Of the writ petition.
Lordship, yes.
Yes.
Lordship, kindly see, with reference to your representation on the subject cited above, I am directed to inform you that the accreditation list published in 22/8/22 is in continuation of the accreditation list published in 4/3/22 in pursuance to the High Court judgment dated 10/2/22.
Now, what is this gradation list of 4/3?
4/3, Your Lordship, that has not been.
This 4/3 was prepared after by following the judgment of 10/2.
Lordship, yes.
Yes, it was prepared.
Where is that?
You'll find in my rejoinder as well, my lord, that 4/3/2022.
What is the gradation list? What was the date of the gradation list which was challenged before the single bench in that earlier round of litigation?
Accreditation list, that is of 2014.
2014.
Lordship.
Now that stood interfered with.
Yes.
Yes, Your Lordship.
And thereafter, a fresh gradation list came on 4/3/2022.
Yes, Your Lordship.
Yes, ma'am.
Now this 4/3/2022 came when you all were in the junior grade.
Yes.
Your promotion was not made to the seniors, isn't it?
Yes.
Now, is it not that after preparation of 4/3/2022 gradation list, this
Promotion is
judgment of the single bench became irrelevant?
No,
No.
it cannot be. No. It cannot be.
Now, thereafter, they were immediately thereafter they were promoted
Yes.
to the,
Senior grade.
A senior grade.
and then subsequently after their promotion, the 22/8 senior
Gradation is.
gradation list comes, which is subject matter in issue in this case, isn't it?
Yes.
No, that promotion is not the subject matter, Your Lordship. Here.
The gradation
Only the
list.
gradation.
It is only the accreditation list. Your
Promotion
Lordship.
is which date? Promotion is
The promotion, Your Lordship, kindly have our affidavit, Your Lordship, at
just a
page
minute.
61.
No, this is gradation list. That is what is changed. 22/8/2022 is a gradation.
That is
list.
accreditation
So
list.
that is under challenge here.
Yes, that is under challenge. But the promotion on 7/3/22 was not under challenge.
Where is that promotion
Lordship
gradation,
will,
gradation list of 4/3/2022? 4/3/2022.
Yes, it's in my rejoinder, my lord.
Let me see.
It is there in your rejoinder.
Oh, sorry, affidavit, my lord. Sorry.
In your affidavit of opposition.
Page 49.
Okay. And the promotion came there, isn't it?
Lordship, yes. Lordship will find the order of promotion at
Page
page
49
61.
of your
Page of affidavit, my lord.
You give us on this one, so that will make yeah. Give me your feedback. see.
See, this says, in pursuance to the judgment of the Honorable High Court, so and so, so and so.
Yes.
Yes. So that has been done in compliance with the order,
Yes.
isn't it?
Yes, Your Lordship.
So is it not that after preparation of this gradation list, the judgment rendered earlier lost its relevance?
No, my lord.
That is the prime point of argument of Mr. Jindal, and probably that is where we needed some what your things. Okay.
Kindly see, Your Lordship, the preparation of the gradation list of 22/8/22, Your Lordship. 22/8/2022, Your Lordship. Then 4/3/2022. That has been done, Your Lordship, in tune with the judgment passed by
See, Mr.
in the earlier
Mr. Sulai,
petition.
Mr. Sulai, you understood what you said. It is not that the court has not understood your point. The fact remains that issue before the earlier round of litigation was with regard to the fixation of seniority in the post where they were recruited.
Lordship,
in the junior grade.
we'll have to turn back, we'll have to go back to 2014. We'll have to go back to 2014.
Yes.
2014, Your Lordship, they were above. They were
No, we
below.
understood that.
Yes, Your Lordship.
It is not issue. Forget about that issue. After the judgment of the single bench, what happened? The seniority was rearranged. A fresh gradation list was prepared.
Yes. Yes.
Mr. Momin was made senior to Mr. Jindal.
Yes.
Issue ended there,
Yes.
and that was done with by notification dated 4th March 2022.
Yes.
Correct?
Lordship, yes.
So then judgment has been complied with.
Yes.
Over.
Over.
Now they are promoted to the next grade.
So that list will continue, will go on, Your
So
Lordship.
that is where we
That
need-
list will go on, Your Lordship. It will go on, Your
So
Lordship.
that is
Will go
where,
on.
by virtue
Yes.
of what rule? By virtue of what rule? It will go on. If you had to say that, it means, wait, just a minute. The matter, the court's query has not ended. Just be patient. Be patient. Before you reply to the response to the court, be patient. Allow the court to finish the question. Now tell us, what is the provision for fixing seniority in the promotional post?
Lordship, that is.
Is it against 16.4 or some other provision?
No, Your Lordship.
So that is where, but then this promotion comes under 16.4. Court has, this is a, see like the
No.
court has to,
Promotion is not under 16.4, my lord.
No, Your
It's
Lordship.
22, my lord.
Lordship, kindly come to the.
but then again you have said that just now that this is applies, that is why now you are altering. your
kindly come to the state affidavit, Your Lordship, at page 61.
Is it because you want to say that is a clerical error or something or what? You just take a stand. You cannot say that it applies and say that the provision applies, but then its contents doesn't
No, the
apply.
promotion was made under rules, Rule 22, Your Lordship.
It's there, my lord.
Kindly come to page
Not
61.
promotion, the gradation. Promotion is promotion. That
The
is okay.
gradation was done under Rule 16.4, Your Lordship, in tune with the judgment
So whether Rule 16 will be applicable
at the
for
promotional
fixing-
stage.
Yes, that is the question. of the
No,
query.
Your
The
Lordship. Rule 22 will be
that is
applicable
what
in
now you're saying-
so
now
far
you're
promotion
saying
is
something else
concerned,
which
Your
was not the
Lordship.
basis.
So far promotion is concerned, there is another rule, Your
Now
Lordship.
your submission is not the same which you started with. You initially did not say so 16.
No, because here, Your Lordship, why I did not touch the promotion, Your Lordship, because the promotion was not an issue before in the was not a challenge.
Promotion is not at all an issue. This Mr. Jindal's also is not at all issue. He is not made promotion an issue.
Because the submission are advance promotion.
If you
No.
if you want to say no. If you want to say that the seniority which is maintained in the promotional order, that is to be maintained for future courts, then if you say so, then you have to say by virtue of what provision.
Rule
Okay.
22.
And when you have a separate list of promotion and separate gradation list in the promotional post, that is where you have to show under what provision of law you have prepared the provision.
Lordship, so far rule 16.4, Your
Okay,
Lordship.
now court has understood the thing probably. Yes, Mr. General, you want to say? Please give us your point.
Lordship.
Two very quick responses, my lord.
Yes, please.
On 16.4 itself, Just,
Yes, yes, please.
just in a humble attempt to.
The entire
to-
thing had become a mess, you see, like.
My lord, I appreciate that. Just a humble attempt to try and clarify things for my lord. See, if their contention, if I've understood correctly, is once promotion is conducted, 16.4 will not apply. Lordship's repeated query was, then what will apply? No answer.
No, but then, see, because it is not there, that stand they have not taken, because their own order
Yes, ma'am.
refers to 16.4.
Exactly. That's
And
why
they
the-
have not come with the plea that it is a clerical error, it's a wrong quotation, nothing.
That's why the
And that has taken the court basically a toll on the court to make them understand what court is asking.
My lord, if the stand of the respondents is that 16.4 will not apply, and it is only the High Court, the 2022 single bench judgment, which will determine my position on that impugned gradation list, my lord, this submission cannot stand. For the simple reason that Lordship will kindly appreciate a gradation list that has been prepared, that is under challenge, is not confined only to my batch. It is for the entire MCS service in the state of Meghalaya. So, any MCS officer serving
Exactly, that is why the paragraph 10 of that judgment, which was read
Yes,
out,
my lord. Yes, my lord. Yes, my no.
that apple and oranges question. See, the court needed to basically.
Yes, my lord. Yes, my lord.
Anyway, please.
No,
please.
no. My point is slightly different, my lord. My point is that impugned gradation list of 2022, August 2022, which we are challenging, contains the names of every MCS officer in the state of Meghalaya, including my batch, the batch that was recruited, selected in 2010, my lord. So, therefore, if they're saying that 16.4 will not apply to that gradation list, then the other officers of the other batches, how is their seniority being determined on the basis of 2000 Justice Banerjee's judgment?
See, Mr. General, it is not that. 16.4 has to apply so far as the fixation of seniority or gradation list in the
My lord.
original
My lord.
post is concerned.
My lord.
Even if there is a judgment.
Yes, ma'am.
Now, just because the proportion of judgment is applied, it will not make 16.4 inapplicable.
Absolutely, my lord. Absolutely.
See, so that remains.
My lord,
It is judgment comes only because, according to the court, there is the incorrect application of 16.4.
my lord.
So, by virtue of the judgment, that incorrect part stands corrected.
My lord, I'm very grateful that Lordship has expressed his
No,
mind.
that is
because
what the understanding of the court.
that-
The
that-
expression of the understanding.
That is my submission also before this honorable court. So I'm very grateful that Lordship has expressed Lordship's mind. So it just makes my job a little easier. My lord, the amendment of the rules of which Mr. Momin has relied on, if Lordship kindly sees that amendment, this is my second submission, second quick response, my lord. If Lordship kindly looks at the notification.
Yes.
Now, with respect, my lord, I have to express my surprise at why this is being referred to, because this has no application to me. If I'm allowed to read, my lord, the amendment, the Rule 3 has been amended.
Yes.
The appointment of MCS officers to the heads of department level.
Yes.
Now, this speaks of appointment to the heads of department level. That is not an issue in our case, my lord. Shall be made by the governor from amongst the members of the service in the senior scale. So there is a senior scale of which I am a part of as on date. Now, if I am to be appointed to head of department, then
this rule will not apply. This rule will not apply to you.
Then this amendment will come in, my lord. So, my lord,
So this amended part basically doesn't apply to you.
it has no play. It has no relevance to the to today's case, my lord. So they could.
Now, Mr. Jindal,
My lord.
if you see the amendment,
Yes, my lord.
this comes as an addition, not by replacing the original provision, isn't it? In the main rule.
True, my lord. True, my lord.
Yes.
No point. The point.
See, other so far as the other provision of Rule 22 is concerned, that remains.
That remains, my lord. And my point still also remains that this amendment being referred to today has no relevance, my lord. Has no relevance. Number two, my lord.
It only applies only in case where you are sought to be appointed in as a head of the department.
As a head of department, my lord. And number three, my lord. My last quick response is on the point of res judicata, my lord, which state respondents have vehemently argued upon. Now, my lord, because of the issue that is being raised, Lordship will kindly allow me to go back to the basics and try and show to this honourable court with respect to what is res judicata and is it applicable to me, my lord, in the present situation, my lord. This is a 4-bench judgment from 1966, possibly the authority on res judicata, my lord. If Lordship kindly looks at para 9 on the next page, my lord.
Yes.
I'll read, my lord. A plain reading of section 11 that covers res judicata. Section 11 shows that to constitute a matter res judicata, the following conditions must be satisfied, namely, number 1, the matter directly and substantially in issue in the subsequent suit or issue must be the same matter which was directly and
Are you
substantially.
raising a very technical plea?
My lord,
We all know that CPC does not apply to writ petition.
my lord,
There
the
is no dispute.
principle of res
What is the
judicata,
principle?
because
Now, the principle, does it mean that we follow the letters or the spirit, whatever?
no, spirit at least, if not the letter, my lord, because in their affidavit and in their oral submissions, res judicata is possibly the central.
If you are trying to raise a very technical issue, then that
No, I mean the issue is slightly complicated enough. I will not try and complicate it further. So I will hold my hand on this issue. But the point is very simple, my lord. Res judicata, for res judicata to apply, the earlier suit, the earlier proceeding, should have dealt with the exact same question, which is the subject matter of today's proceeding, my lord. Today's proceeding is my seniority in the senior grade.
The court has understood the moment you started your argument.
My lord, I am very grateful. My lord, these were my very quick, short responses. The lordship would allow us to file written
Definitely, that is needed. See,
Yes,
that
ma'am.
is,
Yes,
because these minute points,
Yes, ma'am.
though we know the things, but then the
Yes, ma'am. No, for the
small points,
assistance.
whatever you want to
For
find,
lordship's
that will
assistance,
be
my lord.
Okay, we'll just conclude so far as oral argument is concerned, and then please give your written notes.
We'll file it.
Hard learning council for the learning council appearing for the parties. I have concluded their written, their oral argument. Let's wait for. When shall we fix it?
A week's time.
After the next is all we go by.
No, just for submission.
Let be after 2 weeks, your lordship.
Just for
Then.
filing, my lord.
Yes. Let's wait for the parties. At least after 2 weeks for submission of written notes of the oral argument advanced by the parties.
Apply.
Thank you. And don't mind the impatience of the court.
No, not at all. No, your lordship.
Sometimes court.
26.
Obliged.